When a seller is flagged with counterfeit complaints, the product is legitimate. What can they do?
Okay, let's take a step back first. So a brand sees that a seller is selling their products and they're getting it at cheaper prices and they're selling it at better prices. This is all about brands protecting their market, protecting their pricing. And the complaint goes through this really lackadaisical form that Amazon has. Many sellers are aware. It's like 5 boxes you fill out. You don't need to own anything. You don't need to prove anything. You can just make this complaint with like no information. That goes to Amazon's team, and from our cross-examination of Amazon's witnesses at countless arbitrations, it's being evaluated by people in India who, as far as we are aware, have absolutely zero training. Now, Travis, once Amazon receives these complaints, whether they're entirely baseless or might have some merit, what happens next?
Unfortunately, they leave far too much power in the hands of the complainant. Realistically, what Amazon now wants you to do, Amazon takes a step back. They don't know the merits of the claim, but they want you to resolve it with the complainant directly. This gives a lot of power to the complainant because ultimately it's up to them to retract the complaint to see it removed off your account. You can't appeal it, but it's a little bit more challenging than if the complainant was able to retract. And in cases where there is no basis, they shouldn't have any issue retracts, but unfortunately this is an ongoing problem where they refuse to do so they can continue to enforce their exclusivity, regulate their sales channels, and knock off unauthorized sellers.
Now sit tight. We're going to get to the strengths that sellers have shortly. And basically when Amazon receives these complaints that have no basis at all, it's entirely nonsense, you're selling genuine products, Amazon staff in Hyderabad and Bangalore, without legal training, doesn't have the ability to do a really thorough evaluation or any evaluation, and they knock sellers off the listing and they cause the suspension of sellers' accounts, which cause you significant damages. And in a few moments, we're going to get to what you can do against those brands if they refuse to retract or they just cost you tens of thousands or hundreds of thousands of dollars of damages. So stay tuned. We're going to get there. We're just giving you the background so you understand where the complaints come from, how problematic Amazon's system is, how brands take advantage of it, and then we're going to teach you what you can do about sellers' rights.
Right, so
I apologize if I'm screaming. Dana's kind of soft-spoken, so
Well,
apologies in advance. I'm like screaming at the sellers. We are so enthusiastic about taking sellers' rights and enforcing them against the brands. We're going to get to it in a few minutes, and I'll try not to scream anymore.
I have drafted plenty of counterfeit notice dispute appeals. Even if the seller has gotten a product from, let's say, Macy's or a retail location where it's very obvious that these products are not counterfeit. And Amazon recently, that I've noticed, has been very big on receiving those retractions rather than receiving the proof of authenticity. And when we do send the proof of authenticity, it actually does not work. They want that retraction. So what happens? What can the seller do? Because it seems like it's an endless cycle when you appeal with Amazon.
Here we go, Travis. Let's get into the strength that sellers have. You hit one legal cause of action, I will hit the other. And I'm screaming again. We are not racing you into court. We just want you to know what your strength is and what your options are.
Sure. So there are 2 causes of action that a seller may be able to bring in a circumstance like this. I'll go over the first one. The first is defamation. Defamation, the law varies from state to state, but using New York as an example, is a false statement published to a third party without privilege or authorization with fault amounting to at least negligence that caused special harm or defamation per se. Now, when you look to the negligence in these instances, a simple email, a cease and desist letter, possibly a phone call could have revealed that the products were truly genuine. You could have taken 5 minutes to ascertain this information before filing the complaint against these individuals, so it's typically pretty straightforward to prove the negligence in cases like this. Now, they're making a defaming statement to Amazon. They're promoting this statement, and most of all, this statement is extremely damaging. Of all the types of infringement you could receive on Amazon, counterfeit is taken far more seriously. If there's a trademark dispute, if there's a copyright or patent dispute, ultimately this is between brands and the other sellers. But when there's a counterfeit complaint, Amazon now steps in because they're worried that there's going to be knockoff goods being sold on their platform. Now they have a vested interest to keep you off their platform, which usually results in a suspension of their account.
Now let me throw something else out there when it comes to defamation. If you're being accused of selling counterfeit products, that is a crime. I'm finally not screaming, right?
No, you're not screaming.
Okay, so I'm not screaming. Being accused of selling counterfeit products means you're being accused of a crime. And in many states, that is what's called defamation per se, where you may not even have to prove damages in order to recover money against that brand or have significant leverage against the brand because they have done something that is a tort, clear liability, where they may owe you money, and that could also help get those complaints retracted. Okay, the second cause of action is called intentional. I love the thumbs up. Whoever's doing the thumbs up, I can't read the screen from where we are. Thank you very much. So also whoever's joined us live, thank you very much for joining us. The second cause of action is called it's called tortious interference with contract. A tort is a civil wrong where you can sue somebody for money damages. Just like a car accident, a trip and fall, the doctor cuts off the wrong leg. It's a tort. You can recover money damages. And the interference with contract means that the brand made a complaint, they interfered with your contract to sell products with Amazon, and they caused you damages. So most sellers, or all sellers, have a contract with Amazon. And again, if you're selling 100% genuine products, okay, and a brand makes that complaint against you, they've interfered with that contract, so they're trying to knock you off and control the sales.
Right.
Right, and even just furthering off that, when you look to the fact, like CJ said, knowingly, interfering with a contract, like he said, if you're a seller on Amazon, everybody who's a seller must be involved with the BSA agreement with Amazon. There's an active contract. As these complainants themselves do business on Amazon, it's expected that they should know that everybody they're filing against has an active contract with Amazon. And to further that, when you file an infringement, you can review all the policies on a reporting infringement, and when you do, it lets you know the repercussions this can have, including the suspension of their account, which in sense is a termination of their contract with Amazon.
Now Dana asked me what sellers can do with this information, how they can take this information and fight back to the brands.
Okay, so what can sellers do with this information, and how can they take this and fight back?
I love that you asked me that question. Perfect question. Okay, what you sellers can do is, number one, show that the products are, first you need to be certain your products are 100% genuine, that they are absolutely not counterfeit. And you can tell the brand, hey listen, if you don't withdraw that complaint, I'm coming after you. I'm coming after you for every single dollar that we have lost. If you are in the process of selling your Amazon-based business, the decrease in the value because you have that IP complaint, you could sue them for that money too. Now you don't have to rush into court, but you can use this as leverage, okay? Leverage is power to get that complaint retracted quickly, okay? Now, I don't want to rush anybody into court. We are not the traditional law firm. We try and resolve things amicably. But let's say you cannot persuade that brand to withdraw their complaint quickly, or you've lost a tremendous amount of money because something the NFL did, or Major League Baseball, or Nike, or Under Armour, or any of the big brands out there. Travis, let's talk about the damages. How can a seller stand up to these brands and say, you owe me money for my lost sales?
Well, for starts, when you look at the damages, being the most obvious, look at the losses that you've sustained while the account's been suspended. Their defaming statement, their involvement, their interference with your contract is a proximate cause of the losses you're taking. So the first thing we do is always calculate how many sales they've lost in that month, costs associated, can they pay back their credit card bills, other things. There's tons of damages. In addition to that, going with CJ said, there's the reputation at hand. Can this business now thrive even if they get back on Amazon? Or is Amazon going to have a note in the back end stating that this individual has been alleged for selling counterfeit products, whereas maybe they could have gotten 10 more complaints before being suspended again? Now they get one complaint and they're immediately suspended because their reputation is slightly tainted by this allegation.
Now, Travis mentioned proximate cause. Proximate cause is legalese. In the law, when you're suing somebody, proximate cause just means it's a substantial factor in causing the harm, not the only cause. So you literally could have had some other problems with your account, and then this sent you over the edge. And there could even be other complaints by that same brand alleging other things, like they allege you're an unauthorized seller, or the brand allege you can't match their warranty. Those things all might be true, and they all may have had a role in you suffering your damages. But since the standard is proximate cause, not the only cause, you may still have a case against that brand. And if you're not into suing them and there's not enough money at issue to warrant the cost of litigation, this is your leverage to get those complaints withdrawn and possibly some other remedies from these brands.
Right. And then even going further off what CJ just said, we always tell sellers to be mindful of their claims. So he mentioned a warranty not being applicable. There are certain instances, as sellers might or might not know, the first sale doctrine does permit you to resell something lawfully. However, the exception is if there's a material difference. A lot of brands allege that the warranty is not included. To date, courts have upheld that could constitute a material difference, which brings a claim for trademark infringement.
Which is entirely different from sorry to cut you off, Travis.
Okay.
Counterfeit complaints, okay? Sellers out there, if you have been falsely accused of selling counterfeit products, we need to hear from you, okay? We need to hear from you. Have a free consultation with me, with Travis. We want to strike back at these brands. We want to put them back in their place. We want to let them know that Amazon sellers are not impotent. You have rights, you need to know about them, and the brands, I think, need to know. We need to stop the brands from needlessly causing sellers suspensions, account, and listings. All right, Dana, we've covered a lot of ground.
Right.
We've taught sellers what the difference is between counterfeit and other types of complaints. We've talked to sellers how to avoid litigation, but they still have leverage, and the damages they can recover if they choose to go forward, if the damages are worthwhile. You have your list of questions for us. Is there anything else that Travis and I have not yet covered when it comes to sellers' rights if they receive baseless counterfeit complaints?
No, we've covered everything. Everything that was on my list is covered.
Okay, Travis, anything you want to add?
No, I believe we've covered just about all of it.
All right, Amazon sellers all over the world. If you have any questions about counterfeit complaints that you have received when you're selling genuine products, call me, email me, 8779sellers, 8779sellers, or CJ at AmazonSellersLawyer.com. Sellers is plural, lawyer is singular. Also, we have built this practice, okay? Anthony Familaro and I have built this practice on making sure that Amazon sellers have a human being to talk to if you have any issues at all. You can speak with me, you can ask for Dana, you can speak with Travis, any member of our team. We are here for you. And if there's any specific questions you have on this topic, please post them and we will write back to you as quickly as possible. Thank you for joining us for this webinar about sellers' rights. And Travis, thank you very much. Dana, you rock as always. Okay? And Amazon sellers, call us or write us with any questions that you have. Thank you very much for joining us for this live webinar.